6201. Grounds for attachment. An order of attachment may be granted in any action, except a matrimonial action, where the plaintiff has demanded and would be entitled, in whole or in part, or in the alternative, to a money judgment against one or more defendants, when 1. The defendant is a non-domiciliary residing without the state, or is a foreign corporation not qualified to do business in the state, or 2. The defendant resides or is domiciled in the state and cannot be personally served despite diligent efforts to do so, or 3. The defendant, with intent to defraud his creditors or frustrate the enforcement of a judgment that might be rendered in plaintiff's favor, has assigned, disposed of, encumbered or secreted property, or removed it from the state or is about to do any of these acts, or 4. The action is brought by the victim or the representative of the victim of a crime, as defined in subdivision 6 of section 621 of the Executive Law, against the person or the legal representative or assignee of the person convicted of committing such crime and seeks to recover damages sustained as a result of such crime pursuant to section 632A of the Executive Law, or 5. The cause of action is based on a judgment, decree or order of a court of the United States or of any other court which is entitled to full faith and credit in this state, or on a judgment which qualifies for recognition under the provisions of Article 53. 6202. Debt or property subject to attachment. Proper garnishee. Any debt or property against which a money judgment may be enforced as provided in section 5201 is subject to attachment. References to a judgment debtor in section 5201 and in section 105 shall be construed to mean defendant. Double quote. 6203. Attaching creditors' rights in personal property. Where a plaintiff has delivered an order of attachment to a sheriff, the plaintiff's rights in a debt owed to the defendant or in an interest of the defendant in personal property against which debt or property a judgment may be enforced, are superior to the extent of the amount of the attachment to the rights of any transferee of the debt or property, except 1. A transferee who acquired the debt or property before it was levied upon for fair consideration or without knowledge of the order of attachment, or 2. A transferee who acquired the debt or property for fair consideration after it was levied upon without knowledge of the levy while it was not in the possession of the sheriff. 6204. Discharge of garnishee's obligation. A person who, pursuant to an order of attachment, pays or delivers to the sheriff money or other personal property in which a defendant has or will have an interest, or so pays a debt he owes the defendant, is discharged from his obligation to the defendant to the extent of the payment or delivery. 6205. Order of attachment in certain cases. An order of attachment may be granted in aid of execution to a party that has been awarded a money judgment against a foreign state, as defined in 28 United States Code C, in accordance with and subject to the limitations of 28 United States Code section 1610 and other applicable law. 6210. Order of attachment on notice. Temporary restraining order. Contents. Upon a motion on notice for an order of attachment, the court may, without notice to the defendant, grant a temporary restraining order prohibiting the transfer of assets via garnishee. The contents of the order of attachment shall be as provided in subdivision of section 6211. 6211. Order of attachment without notice. When granted. Contents. An order of attachment may be granted without notice, before or after service of summons and at any time prior to judgment, or as provided in section 6205 of this article. It shall specify the amount to be secured by the order of attachment including any interest, costs and sheriff's fees and expenses, be endorsed with the name and address of the plaintiff's attorney and shall be directed to the sheriff of any county or of the city of New York where any property in which the defendant has an interest is located or where a garnishee may be served. The order shall direct the sheriff to levy within his jurisdiction, at any time before final judgment, upon such property in which the defendant has an interest and upon such debts owing to the defendant as will satisfy the amount specified in the order of attachment. B. Confirmation of order, except where an order of attachment is granted on the grounds specified in subdivision 1 of section 6201. An order of attachment granted without notice shall provide that within a period not to exceed 5 days after levy, the plaintiff shall move, on such notice as the court shall direct to the defendant, the garnishee, if any, and the sheriff, for an order confirming the order of attachment. Where an order of attachment without notice is granted on the grounds specified in
confirming the order of attachment. where an order of attachment without notice is granted on the grounds specified in
Subdivision 1 of Section 6201, the court shall direct that the statement required by Section 6219 be served within 5 days. Subdivision 1 of Section 6201, the court shall direct that the statement required by Section 6219 be served within 5 days, that a copy thereof be served upon the plaintiff, and the plaintiff shall move within 10 days after levy for an order confirming the order of attachment. If the plaintiff upon such motion shall show that the statement has not been served and that the plaintiff will be unable to satisfy the requirement of subdivision B of Section 6223 until the statement has been served, the court may grant one extension of the time to move for confirmation for a period not to exceed 10 days. If plaintiff fails to make such motion within the required period, the order of attachment and any levy thereunder shall have no further effect and shall be vacated upon motion. Upon the motion to confirm, the provisions of subdivision B of Section 6223 shall apply. An order of attachment granted without notice may provide that the sheriff refrain from taking any property levied upon into his actual custody, pending further order of the court. Rule 6212. Motion papers, undertaking, filing, demand, damages, affidavit, other papers, on a motion for an order of attachment, or for an order to confirm an order of attachment, the plaintiff shall show, by affidavit and such other written evidence as may be submitted, that there is a cause of action, that it is probable that the plaintiff will succeed on the merits, that one or more grounds for attachment provided in Section 6201 exist, and that the amount demanded from the defendant exceeds all counterclaims known to the plaintiff. B. Undertaking. On a motion for an order of attachment, the plaintiff shall give an undertaking, in a total amount fixed by the court, but not less than $500, a specified part thereof conditioned that the plaintiff shall pay to the defendant all costs and damages, including reasonable attorney's fees, which may be sustained by reason of the attachment if the defendant recovers judgment or if it is finally decided that the plaintiff was not entitled to an attachment of the defendant's property, and the balance conditioned that the plaintiff shall pay to the sheriff all of his allowable fees. The attorney for the plaintiff shall not be liable to the sheriff for such fees. The surety on the undertaking shall not be discharged except upon notice to the sheriff. C. Filing. Within 10 days after the granting of an order of attachment, the plaintiff shall file it and the affidavit and other papers upon which it was based and the summons and complaint in the action. Unless the time for filing has been extended, the order shall be invalid if not so filed. D. Demand for papers. At any time after property has been levied upon, the defendant may serve upon the plaintiff a written demand that the papers upon which the order of attachment was granted and the levy may be served upon him, not more than 1 day after service of the demand. The plaintiff shall cause the papers demanded to be served at the address specified in the demand. A demand under this subdivision shall not of itself constitute an appearance in the action. E. Damages. The plaintiff shall be liable to the defendant for all costs and damages. Plaintiff's liability shall not be limited by the amount of the undertaking. 6213. Service of summons. An order of attachment granted before service is made on the defendant against whom the attachment is granted is valid only if, within 60 days after the order is granted, a summons is served upon the defendant or first publication of the summons against the defendant is made pursuant to an order and publication is subsequently completed. If the defendant dies within 60 days after the order is granted and before the summons is served upon him or publication is completed, the order is valid only if the summons is served upon his executor or administrator within 60 days after letters are issued. On good cause shown, the court may extend the time, not exceeding 60 days, within which the summons must be served or publication commenced pursuant to this section, provided that the application for extension is made before the expiration of the time fixed. 6214. Levy upon personal property by service of order. Method of levy. The sheriff shall levy upon any interest of the defendant in personal property, or upon any debt owed to the defendant, by serving a copy of the order of attachment upon the garnishee, or upon the defendant in the same manner as a summons, except that such service shall not be made by delivery of a copy to a person authorized to receive service of summons solely by a designation filed pursuant to a provision of law other than Rule 318. B. Effect of levy. Prohibition of transfer. A levy by service of an order of attachment upon a person other than the defendant is effective only if, at the time of service, Such person owes a debt to the defendant, or such person is in the possession or custody of property in which such person knows or has reason to believe the defendant has an interest, including any specified in the notice, then due and thereafter coming due to the defendant, shall be subject to the levy, unless the court orders otherwise. The person served with the order shall forthwith transfer or deliver all such property, and pay all such debts upon maturity, up to the amount specified in the order of attachment, to the sheriff, and execute any document necessary to effect the payment, transfer or delivery. After such payment, transfer or delivery, property coming into the possession or custody of the garnishee, or debt incurred by him, shall not be subject to the levy, until such payment, transfer or delivery is made, or until the expiration of 90 days after the service of the order of attachment upon him, shall not be subject to the levy, until such payment, transfer or delivery is made, or until the expiration of 90 days after the service of the order of attachment upon him, or of such further time as is provided by any subsequent order of the court served upon him. Whichever event first occurs, the garnishee is forbidden to make or suffer any sale, assignment or transfer of, to any person other than the sheriff, except upon direction of the sheriff, except upon direction of the sheriff, except upon direction of the sheriff or pursuant to an order of the court. A garnishee, however, may collect or redeem an instrument received by him for such purpose, and he may sell or transfer in good faith property held as collateral or otherwise pursuant to pledge thereof, or at the direction of any person other than the defendant authorized to direct sale or transfer, provided that the proceeds in which the defendant has an interest be retained subject to the levy. Provided that the proceeds in which the defendant has an interest be retained subject to the levy. A plaintiff who has specified personal property or debt to be levied upon in a notice served with an order of attachment shall be liable to the owner of the property or the person to whom the debt is owed, if other than the defendant, for any damages sustained by reason of the levy. Seizure by sheriff. Notice of satisfaction. Where property or debts have been levied upon by service of an order of attachment, the sheriff shall take into his actual custody all such property capable of delivery, and shall collect and receive all such debts. When the sheriff has taken into his actual custody property or debts having value sufficient to satisfy the amount specified in the order of attachment, the sheriff shall notify the defendant and each person upon whom the order of attachment was served that the order of attachment has been fully executed. D. Proceeding to compel payment or delivery. Where property or debts have been levied upon by service of an order of attachment,
The plaintiff may commence a special proceeding against the garnishee served with the order to compel the payment,
delivery or transfer to the sheriff of such property or debts, or to secure a judgment against the garnishee. Notice of petition shall also be served upon the parties to the action and the sheriff. A garnishee may interpose any defense or counterclaim which he might have interposed against the defendant if sued by him. The court may permit any adverse claimant to intervene in the proceeding and may determine his rights in accordance with section 6221. E. Failure to proceed. At the expiration of 90 days after a levy is made by service of the order of attachment, or of such further time as the court, upon motion of the plaintiff on notice to the parties to the action, has provided, the levy shall be void except as to property or debts which the sheriff has taken into his actual custody, collected or received, or as to which a proceeding under subdivision D has been commenced. 6215. Levy upon personal property by seizure. If the plaintiff shall so direct and shall furnish the sheriff indemnity satisfactory to him or fixed by the court, the sheriff, as an alternative to the method prescribed by section 6214, shall levy upon property capable of delivery by taking the property into his actual custody. 6216. Levy upon real property. The sheriff shall levy upon any interest of the defendant in real property by filing with the clerk of the county in which the property is located a notice of attachment endorsed with the name and address of the plaintiff's attorney and state address of the plaintiff's attorney, and stating the names of the parties to the action, the amount specified in the order of attachment, and a description of the property levied upon. The clerk shall record and index the notice in the same books, in the same manner and with the same effect, as a notice of the pendency of an action. 6217. Additional undertaking to carry a garnishee. A garnishee who is a common carrier may transport or deliver property actually loaded on a conveyance, notwithstanding the service upon him of an order of attachment, if it was loaded without reason to believe that an order of attachment affecting the property had been granted, unless the plaintiff gives an undertaking in an amount fixed by the court, that the plaintiff shall pay any such carrier all expenses and damages which may be incurred for unloading the property and for detention of the conveyance necessary for that purpose.